Gustavo, and 27 others.
As it pleases the court, my lady, I still appear for the state with Mr. Marondeza.
Ms. Gebhardt?
May it please the court, my lady, I appear for accused 1 as well as accused number 11 in this matter. I'm instructed by the Directorate of Legal Aid, my lady.
Case number 2, Mr. Hatuikulipi, still in person?
Yes, morning, Judge.
Morning all. Mr. Shangala, in person?
Yes, indeed. Good morning, Judge.
Case number 6, Mr. Mwatelulo, you're still in person? Mr. Beerkus?
Yes, here on behalf of accused 4 and 24 in this matter. My lady, I'm also standing in for Mr. Alexander in respect of accused 7. My lady, Mr. Alexander requested me to convey his apologies for not being able to attend to the proceedings today. He is currently having a family medical emergency. And he said if the matter is rolled over to tomorrow, he will then be available as it is the court.
Thank you.
As the court places, my lady. My lady, I appear on behalf of accused number 9 and 26. I'm standing in for Samherji, who's out of town, unfortunately, as for accused number 5, 10, 12, 13, and 14.
Thank you.
As the court places.
Mr. Nimwatya?
As it may please the court, my lady, to confirm appearance for accused number 8, as well as the entities that he represents. My lady, I also received a text message from Mr. Siyomunji requesting that I stand in for accused number 5, 10, 12, 13, and 14. He says that he's out of town.
Thank you. Yes, I think we will deal with the application for leave to appeal the postponement ruling first. I see that all the parties do have points in limine. Mr. Nimwatya, you have 2 points in limine.
That is correct, my lady.
Then I see the state and Ms. Gebhardt likewise both have 2 points in limine. They are the same. So what we will do is, Mr. Nimwatya, you will address us on your points in limine. The state and Ms. Gebhardt will get an opportunity to reply there too. And then the state and Ms. Gebhardt will address us on their points in limine, and you likewise will have an opportunity to reply there too. I will not hear arguments today on the grounds of appeal, solely on the points in limine. Mr. Nimwatya, if you are ready, you may proceed.
My apologies, Judge.
As it may please.
My apologies. May I inquire if the court has received the leave of appeal that
Yes,
you have?
yes. We will deal with that later.
As it pleases the court.
God blesses, my lady. Accused number 8, my lady, raised 2 points in limine. The first one is obviously a conditional one, and that was based on the condition that should accused number 2 and 3 the thing number, accused number 2 and 3, that applied for the recusal of the Honorable Judge, should they note their appeal, their intent to appeal the ruling on the recusal application, that the application for leave to appeal, which is this particular application, cannot be heard before the recusal application is actually disposed of, including the notice to appeal that particular recusal application. In our view, my lady, we are of the view that because the recusal itself goes against the impartiality of the court, as opposed to the appeal that we are noting against the ruling of the court, our submission is that every time the court presides or entertains any other application that comes in between before the appeal on the recusal application has been disposed of by the court, we submit that will be an irregularity. Our position is that, my lady, on this aspect, that the court first entertains the appeal on the recusal application, and thereafter, depending on the outcome that the court gives on that application, the court may then come and attend and entertain the leave to appeal application.
Is it your contention, or would you say there would be any prejudice suffered or irregularity taking place if the court at least hears the application for the leave to appeal on the postponement?
Yes, my lady, we are of the view that the process itself it's just irregular, because let's assume that application for leave to the application for leave to appeal the recusal application succeeds. That will put the court in the hands of the Supreme Court. Which, well, basically, it's simply to say that the procedure itself is just, in our view, not the regular procedure that should take place the way we understand it, because of the reason that we gave, that the recusal is against the court as a whole, and the appeal is against the particular ruling of the court. Moving on, my lady, to the second point in limine, which is that accused number 1 and 11 that also noted, filed their papers to oppose our appeal, that as far as this interlocutory proceeding is concerned, they are not party to these particular proceedings, in the sense that, my lady, and part of the reason why the accused persons number 1 and 11 are opposing, they are citing their right to a trial within a reasonable time. But on the 19th of January, when we came before court to make the application for a postponement, to be afforded reasonable time to prepare, that right was still there, and the accused person number 1 and 11 never opposed that our application that we requested between 5 to 6 months, despite the fact that they were before court. That means that They were not party to that application that we applied for postponement for that period. They can therefore, in our view, not come now when we decided to appeal without, in our view, first seeking leave to participate in the appeal from the Honorable Court. Just file papers to oppose the appeal, just because they are co-accused in the matter. If their argument is that if their argument is that because they are also co-accused, like they gave their reason for the opposition is that they would want to go to trial. If that is the position, why did they not oppose the application on the date that we made it? On the same period that we required the court to grant us. To further understand that the accused persons, number 1 and the 11, are actually not party to this particular application, we must also look at their further reasons or argument that they advanced, in which basically their response to that argument is that this point in limine seems to be a procedural distraction. Without more, they are not denying that they should have filed or sought leave from the Honorable Court to participate, but they simply stated that it appears to be a procedural distraction to delay the matter. We are submitting, my lady, that is not our position. We are simply not here to distract the progress of the matter, but we would want, if they want to participate in this appeal, the proper procedure is that they must first and foremost seek leave from the Honorable Court to participate and intervene in the appeal process to protect their right. In short, my lady, in addition to what is already in our papers on this particular point in limine, those are the main reasons why we raised those 2 points in limine. As it may please the court.
Thank you. Mr. Lutebeze?
As it please the court, my lady. As directed by the court, the state will only deal with the points in limine which have been raised. We stand by the state's set of arguments in this matter. Now, as for the first point in limine, which was raised by the applicant in this case, it had been conditionally raised on the basis that accused 2 and 3 will file the application for leave to appeal the recusal application, which they have in actual fact done in this matter. And the prayer is to stay these proceedings pending the outcome of that recusal application. My lady, there is no legal basis which has been laid by the applicant for the request of their order to stay these proceedings. This court, my lady, there is no order which has been granted by this court or any other court staying these proceedings or which prevents this court from hearing the matter before you. Of significance, my lady, should be pointed out that the application for leave to appeal the judgment on the postponement and the application for leave to appeal the recusal judgment are 2 distinct applications. It is also noteworthy that the applicant in this matter is not even party to the recusal matter, even though he wants to rely on that matter in order to stay the proceedings. My lady, this recusal application, which has now been filed by accused 2 and 3, it does not deprive this court of the power to deal with any ancillary matters, including applications for postponements. Because if that was the case, that this court is deprived of the power to deal with any ancillary matters, it would in actual fact have the impact that this court cannot sit in any matter before it at all. Because what is going to happen at the end of the day today, once these proceedings are concluded, this matter has to be heard on another date. So how does it come about for the court to be postponed, for this matter to be postponed to another date? This court has to give an order to that effect. And in terms of what provisions of the Criminal Procedure Act does the court give that order? It's in terms of Section 168. So this matter, at the end of the day today, when it's postponed for judgment, this court has to give that order that this matter is postponed for judgment. If it is correct, as alluded to by counsel, that this court cannot deal with an application, it means that this court is not empowered to even give the order it's supposed to give at the end of the day today. And there is no legal basis for that at all. We respectfully submit, my lady, that this court is in nature of fact empowered to deal with any ancillary orders which come before it, and these applications for postponements are in nature of fact just any ancillary orders which have to be dealt with by this honorable court. Reference was also made to the matter of State versus Zuma, I see in their list of arguments, where the court had pointed out in that particular case that if it is found at the end of the trial that a judge should have recused himself or herself, the trial will be a nullity, will fall to be set aside in toto, and will have to commence de novo at considerable cost and inconvenience. The above are material consideration which must be present in the mind of the judge when considering the possibility of recusal. That is the only judgment that was relied on. And it is quite clear from this judgment that the issues which were raised therein of the matter starting de novo, that is only one of the considerations that has to be considered by this honorable court in a recusal application and in determining whether or not to proceed with the matter. But we are not seized with any recusal application at this stage. We are just seized with a matter of an application for leave to appeal against the judgment for against the judgment which was granted against the postponement which was sought by the applicants, my lady. My lady, I should just point out that it will not be an irregularity, as counsel pointed out, for this court to dispose of this application. There is no basis that has been laid for such an irregularity occurring in this particular matter. And it is in actual fact in the interest of justice for this matter to be dealt with expeditiously. The court need not only consider the interest of the applicant in this matter, the court should also consider the interest of the co-accused and the state in ensuring that matters are dealt with and finalized expeditiously. If the court grants that order that this matter should be held in abeyance pending the determination of the recusal application, it would mean that this application itself will be stalled until the recusal application is finalized. And that would mean that this matter, which is before court, will then have to be heard after the recusal application. And that will just cause a delay in the proceedings, which is in actual fact then prejudicial to the other parties who are involved in this matter. And that should not be accepted in this case, my lady. My lady, moving on to the second point in limine, which was raised by the applicant. I found this to be an odd point in limine which has been raised. And I think just to put it in context, the point in limine is to the fact that the court failed to observe its own rules by permitting accused one who was not party to the adjournment proceedings to participate in the application for an adjournment in the absence of an application to intervene. That is a point in limine which has been raised now in the application for leave to appeal. My lady, the purpose of the point in limine is that it should be raised at the start of proceedings, so that if that point in limine is upheld by the court, it would mean that the substantive application which concerns that point in limine might not be heard at all by the court. That is the purpose of the point in limine, to curtail some of the proceedings. If a ruling is made in favor of the applicant, then it will result in the substantive application not being held. So this point in limine which has been raised now has not been appropriately raised by the applicant. It should in actual fact have been raised at the time when the application for the postponement was made, when counsel for accused one was heard. At that stage, had the point in limine been raised then, this court would then have been empowered at that stage to bar counsel for accused one from participating in the matter if there was justification for that to be done. But that was not done at all. So to raise this point in limine now is highly irregular, my lady, because this point in limine at this stage should in actual fact have been raised as a ground of appeal or review, whatever the case might be. Because these allegations that the court failed, they are in actual fact informing the court that the court erred in doing A, B, C, and D. So if they have the view that the court erred, this is the ground of appeal. It cannot be raised as a point in limine. So this second point in limine should not even be entertained by this court. From the heads of arguments that were filed by counsel, I could not even see the purpose of the point in limine. What order did he seek this court to make with this point in limine? I waited for him to argue, to hear from him what is the order sought on the basis of this point in limine. There was nothing argued, because there's no order that can be given on the basis of this point in limine. It does not apply on an application for leave to appeal. It's an irregular point in limine, my lady, which is raised at the wrong time. The opportunity to have raised it has far past the application itself. I respectfully submit, my lady, that there is no basis for this point in limine, which has been raised by the applicant. Moreover, the co-accused persons in this case, in actual fact, is indicated in a set of arguments. They are parties to the criminal proceedings. They have an interest in this matter, and they were supposed to be heard in the application for the postponement. It would have been irregular for this court to determine trial dates on the basis of the submissions made by accused Ed's lawyer alone, without hearing what the other lawyers had to say in this matter. Because we should take into consideration that accused one's lawyer and accused Ed's lawyer came before court for the first time on the same date. So was the court then supposed to listen to one lawyer and ignore the other as to the beginning of the trial date? I respectfully submit, my lady, that that should not have been the case. The court was entitled to hear both counsel in order to determine as to which date the matter should be postponed for trial. My lady, the state has also raised its own point in limine in this particular matter. The first point in limine raised by the state, this pertains to the grounds of appeal which have been filed in this matter.
Yes, we will first dispose of the applicant's points in limine, and then we will return to the state's. Ms. Gebhardt?
Yes, please, my lady.
My lady, the applicants raised this point that the leave to appeal hearing should not proceed before this honorable court delivers the judgment on the application for leave to appeal the recusal hearing. So we mustn't conflate the issue. The debate we are having now is not whether the criminal trial will proceed. We will come to that. What we are dealing with now is the point that's being raised, that the application for leave to appeal the postponement orders that were dismissed should not be entertained, ventilated before the recusal leave to appeal has been heard. So that is what we are debating now. So that's where I'll position my submissions. It's common cause, my lady, that accused 2 and 3, as expected, have then filed their leave to appeal the recusal ruling, but that does not assist number 8, because the point in limine remains without merit. The leave to appeal the recusal ruling and the present application, which is the leave to appeal the postponement ruling, are entirely distinct and different applications. There are different rulings that are being looked at and ventilated, and there are different legal issues that we'll have to debate on the merits. So there really is no legal basis for holding the application, this one, in abeyance on the basis of the filing of the separate matter. What is important, and I believe that my colleague has lost sight of this issue, the mere filing of an application to leave to appeal the recusal, or even this one, to appeal the postponement ruling, do not stay the criminal trial proceedings, my lady. And we will have regard to Section 316 of the Criminal Procedure Act for guidance on that matter. My colleague was asked to address the court on what prejudice will be suffered by accused 2 and 3 if we argue the application for leave to appeal the postponement. He failed to answer that question. What he did is to allege an irregularity, a bare allegation, no substantiation, what the nature of that irregularity will be, how it will manifest, and how it will prejudice accused 2 and 3 if we do in fact argue the leave to appeal in respect of the postponement application. He admits that it is indeed an interlocutory application. That's a welcome admission. But what he fails to take cognizance of is to take that admission to its natural conclusion, which is to state to the Honorable Court what the position of your orders are. That application was determined, it was disposed of, that order stands until it's set aside. So this point in limine, the first one, should be dismissed of because of 4 reasons. These proceedings are entirely distinct applications. The second reason is there's no legal basis to hold this application in abeyance pending an unrelated leave to appeal. And you will find the reasoning for that in our principle against piecemeal appeals. We've got a principle in our jurisdiction in criminal matters that says we must not encourage, entertain piecemeal appeals. The third reason, and this is the critical one, is that the mere filing of an application for leave to appeal the recusal does not automatically, in of itself, without a stay order, it does not stay these proceedings. It also does not stay the criminal trial. No stay order has been sought, my lady, nor has one been granted by this court or any other court. So under Section 316 of the Criminal Procedure Act, the filing of a leave to appeal application does not by of itself suspend the criminal trial, nor does it suspend the ventilation of the current application. In any event, my lady, and that's the last reason, any nullity flowing from a future finding on the recusal matter can be addressed at that stage. Accused 2 and 3 are not without remedies. It's then for those reasons, my lady, that I submit that the first point in limine is without any merit and it should be dismissed. I'll move on, my lady, to the second point that has been raised, and that is that accused 1 and 11's participation is without an intervention application. The applicants, my lady, contend that accused 1's legal representative ought to not have been allowed to address the court on the postponement application and to participate in this application without a formal Rule 40 intervention application. And in his address now, my learned friend made the following submission. He says, if they want to participate in this appeal, they must seek leave from the Honorable Court to protect their rights. My learned friend is mistaken with respect. There is no appeal before this court yet. What we are arguing is an application for leave to appeal. He does not have leave yet to file an appeal. He is seeking leave to file an appeal. What we are debating then is this specific one. My learned friend again failed to provide a legal basis or authority for his submission that an intervention application is required in this specific circumstances. This point is misconceived for a number of reasons. The first reason is that the applicant's own legal practitioner served the application for leave to appeal on our offices by email on 11 February 2026. By serving us, the applicant invited our participation. We are here by invitation. So it does not lie in the mouth of the applicant to invite us, and then when we answer in the manner that he does not like, he then says, no, you should not be here. We are here by invitation. A litigant cannot serve an application on a party and then object to that party's participation. This point is clearly self-defeating on its own facts, my lady. The next reason why this point should fail is that on 19 February 2026, my lady, I notified my learned friend, the applicant's legal practitioner, that the application as served appears to be missing a page and requested a complete copy. On 25 February 2026, he acknowledged the request and undertook to forward a complete copy. As of today, my lady, no complete copy has been received. We have had to oppose this application whose completeness we could not verify because the applicant failed to provide it. The third reason why this point is a bad point and should be dismissed is because accused 1 and 11 are parties with a substantial interest in the outcome of this application, meaning accused 1 and 11, whichever way the application goes, that is the application for leave to appeal the postponement ruling, they have an interest in the outcome of that proceedings, and simply on that basis they are allowed to participate. A co-accused in criminal proceedings does not require formal intervention to be heard on an interlocutory matter in proceedings to which he or she is already a party. The next reason why this point should be dismissed is to be found in this court's judgment of Hatuikulipi, (2026) NAHCMD at paragraph 137, at paragraph 17, where your ladyship held that slavish superimposition of civil rules in criminal proceedings will create a hybrid type of procedure. The High Court rules should not be mechanically applied in criminal proceedings. More importantly, the next reason why this point should be dismissed is because the accused 1 and 11 have certain rights under Article 12(1)(b) of our Constitution. And that is the right to a trial within a reasonable period. These rights are directly at stake. They are directly in issue when any postponement or leave to appeal the refusal or granting of a postponement application is being considered. You cannot determine that without having regard to the rights of other co-accused, whether they have opposed or not, their right to a trial within a reasonable period. The last reason why this point should fail, my lady, is simply because, again, even though you foreshadowed it when you asked my learned friend what is the prejudice that would be suffered in the first point, he failed to again address that issue in the second point. What is the prejudice that accused 8 or any other accused person in these proceedings will suffer should accused 1 and 11 but be allowed to participate in the application for leave to appeal the postponement application? He simply does not address that issue because he has no submissions to make in that regard. Because there is no identified prejudice, no demonstrated prejudice that accused 8 will suffer. It's then on that basis, or the reasons that I've advanced, my lady, that the second point in limine should also fail, as it pleases the court.
Thank you, Mr. Nghipunya. Your reply?
Yes, please the court, my lady. My lady, in reply, if I understood Mr. Advocate Lutimbezi very well to be saying that we should have raised the second point in limine on the 19th of January, the date we made the postponement application. If that is what he says, then I differ with him. Because on that particular day, despite the fact that accused 1 and 11 were also heard, they indicated their position and that they were ready to start the trial. They did not make an application for adjournment. It was accused number 8 and other accused persons. When accused number 8 made that application on that day, seeking that period of time of 5 to 6 months, accused number 1 and 11 never opposed that. That is why we are saying they are not party to this application, because even when it was initially made, they never opposed it. And because they never initially opposed it, they cannot just come from Norway and automatically oppose it on the appeal. In response to accused number one's address, that we invited them by serving them the papers to participate. By serving them the papers, we did not indicate to them that we will waive our right to object to your unauthorized intervention. They seem to suggest that the mere filing of saving of papers on them is a waiver of that right to object against their participation, which is not authorized by the court. Just a moment, my lady. Just want to look at something. And to also further add on to that, if the court can also just have a look at paragraph 22, subparagraph 2 of accused number 1's heads of argument. I'm citing this because I want the court to understand why I'm saying they are not party to the application. We are of the view that the reason why they did not oppose, it's because, like it's clear here when they are stating that the rights that we are claiming can still be enforced during the proceedings, that we can still seek for more time. It's simply that they are acknowledging that we should have been given sufficient time to prepare. And it's our submission that that is probably the reason why they never opposed the application on that particular day. And that is what we say. That is the reason we are saying they are not party to this particular application, because they never opposed it, my lady. As it may please the court.
Thank you. That deals with the applicant's points in limine. Mr. Litebeze, for the state, on your points.
As it pleases the court, my lady, the state has similarly raised 2 points in limine. The first point in limine raised relates to the absence of grounds of appeal in the application for leave to appeal. Now, the law is that, as it applies to applications for leave to appeal, has been set down in Section 316 of the Criminal Procedure Act, in particular, Section 316, subsection 2, which provides that every application for leave to appeal shall set forth clearly and specifically the grounds upon which the accused desires to appeal. My lady, we should take note that this application for leave to appeal, it in nature of fact constitutes the formal documents in which the applicants seek for the court's permission to appeal. And the requirements for the grounds of appeal to be clearly and specifically set out in that application are an integral part of the application. It's mandatory that it should be included in the application itself. It is also clear from the provisions of this act that in the application for leave to appeal, it is not required for a party to file an affidavit. An affidavit is only filed in the case where a party intends to adduce further evidence. Then that party has, along with the application for leave to appeal, has to file the affidavit. In this particular case, we note that an affidavit has been filed. It's not clear from the affidavit or arguments as to what further evidence it is that the applicant intends to lead in this particular case, because the affidavit will then contain the evidence that is required by the party. My lady, I also just want to highlight that this law, which governs applications for leave to appeal, can be found at page 10 of the state's heads of arguments. The requirements thereof, with regard to the notices of appeal, have been authoritatively laid down in several judgments. Before I deal with the issues, I just want to highlight what has been said in some of these judgments. We've made reference to the matter of Kwakololo versus the state in paragraph 26 of the state's sides of arguments, where the court highlighted that the noting of an appeal constitutes the very foundation on which the case of the appellant must stand or fall. It serves to inform the trial magistrate in clear and specific terms which part of his or her judgment is being appealed against. The court went on to say, has pointed out at page 11 of the state's heads, that it determines the parameters within which the court of appeal will have to decide the case. It also serves to focus the minds of the judges of appeal when reading sometimes the lengthy records of appeal. This is significant. I will come back to it shortly. Furthermore, in the matter of Peter Dorevard and another versus the state, as cited in paragraph 27, The court pointed out that the law governing notice of appeal and also notice of application for leave to appeal is tried. The grounds of appeal in the notice of application for leave to appeal must be clearly and succinctly set out in unambiguous terms so as to enable the court and the respondent to be fully and properly informed of the case which the applicant seeks to make out and which the respondent is to meet opposing the application for leave to appeal. The court went on to say that the notice should not contain arguments. And this is significant because we know that there's an affidavit which has been attached by the applicant, and that affidavit is full of arguments which have been advanced by the applicant. So in any event, even if the applicant himself has to consider that affidavit, which by the way is not an application itself, has an application, it does not comply with the requirements of section 316, subsection 2. Moreover, in the matter of House Services Estate, in this particular case, my lady, the notice of appeal did not clearly and specifically set out the grounds of appeal. At least the way grounds of appeal are, but they're not clear and specific. The court found that as a result, the original notice of appeal was in fact defective. And in this particular case, the counsel for the applicant intended to prepare and serve an amended notice of appeal. The court ruled on this, and this is what the court had to say at paragraph 8 of the judgment. We now consider the proposition by Mr. Andreas and whether it is sustainable in law that an amended notice of appeal can ratify a defective notice of appeal. There is ample authority that it cannot be done. And there was reference to the matter of Bear versus the state and the Molebetsi case, where it was held that improper grounds of appeal amounts to a nullity, and once a nullity, it cannot be resurrected, it cannot be revived, neither by condonation of the non-compliance nor by amendment of the defective notice. It was furthermore stated that the correct procedure would be to withdraw the appeal and file a fresh notice of appeal with a condonation application for the late filing of the new notice of appeal. So the law is clear. If the notice is defective, it's fatal to the application. In as much as the court may want to condone and hear the application in the interest of justice, it simply cannot be done because it cannot be revived. There's nothing that can be done with an application which is null and void in law. Moreover, in the matter of State versus Kavari, as cited in paragraph 29 of the States of Arguments, the court in this particular case, and I just want to quote what was said by the court at page 5 of the judgment, it stated that the court went on to warn litigants that it would in future require strict compliance with the provisions of Rule 67.1 of the Magistrates Court's rules. A notice in which no grounds were mentioned was not a valid notice of appeal, and as such, it was no notice of appeal at all. It is a nullity which remains a nullity, which could not be resurrected or revived. My lady, looking at the judgments that have been cited by the state, it is right that the applicant must stand or fall by the papers which have been filed. And if we have regard to this particular case, to the heads of arguments which have been filed by the applicant, my lady, has set out in the States of Arguments, the applicant has demonstrated that he is in fact a stickler for the rules and the law. He has urged this court and begged and pleaded with this court to comply with the rules and the law. That is what he has done in his heads of arguments. He's also made reference, he has indicated in paragraph 14 of the States of Arguments, to the case of Minister Ikanjo versus Van der Berg, where it was observed that there are inherent dangers attendant upon the court's failure to apply the law and rules of the court. This is the case cited by the applicant. It then proceeds at paragraph 16 to contend that litigants must at least fail to adhere to the rules of the Honorable Court. So this is the standard which the applicant has set, based on which this application must be decided. And the standard he has set is that there must be compliance with the law. There must be compliance with the rules. So based on that standards, his application must be based on those standards, my lady. And it will be manifestly unfair and unjust if the court is not to hold him to his own standards, which he wants this court to abide to. Now, taking into consideration the standards which he has set for himself that there must be compliance with the rules and the law, what has the applicant filed in this particular case? The applicant's notice is highlighted in paragraph 18 of the States of Heads of Arguments, stipulates as follows. Be pleased to take notice that Be pleased to take notice that the eighth accused hereby files for leave to appeal against the judgment of Honorable Lady Justice Du Plessis, partially dismissing his application for a reasonable, adequate time to prepare for trial delivered on 21 January 2026 at the Windhoek High Court Central Prison. That's all. There's nothing else. That is all that is stipulated in his application. And then he attaches an affidavit which is submitted earlier that this constitutes evidence on which a party must rely on to support the grounds on leave to appeal if there is new evidence. So what is clear from this notice that has been filed, it does not comply with the provision of Section 316(2) of the Criminal Procedure Act. That section requires for the grounds to be stipulated in the application. They must be clearly and specifically stipulated in the application. Here, there isn't a single ground which has been clearly and stipulated by the applicant. In actual fact, what he has filed is it's only a filing notice informing the court that they are going to file a certain application. But where is that application itself? It's nowhere to be found. He has not complied with the provision of Section 316, subsection 2, which he has begged this court to comply with, because he says that the court must comply with the rules and the law. But he himself has not complied with it. And there's no explanation which has been given for doing that. My lady, it should also be noted that the state insists that there should be compliance with this provision by the applicant, because the applicant himself, it's not the first time that he's been involved in filing of notices of appeal applications for leave to appeal. It has been done before. I've made reference to the judgment which has been held by the Supreme Court where notices have been filed by their estoral lawyer. So they know how these applications should look like. And those applications, in actual fact, complied with Section 316(2). There was full compliance. So before this court, the applicants have filed proper applications for leave to appeal, which fully complied with the law. Now, all of a sudden, inexplicably, with their counsel, they choose not to do so for whatever reason. And counsel for the applicant cannot feign ignorance of the provisions of Section 316, subsection 2 of the Criminal Procedure Act, because in his heads of arguments, he in actual fact made reference to the matter of Shangala versus the Prosecutor General. This is a judgment that was delivered on 22 October 2025 in paragraph 26 of his heads of arguments. He made reference to this judgment. And this judgment primarily dealt with the provisions of Section 316, subsection 2, wherein the applicable grounds of appeal and the requirements for the applicable grounds of appeal were restated. And the court held that they must be clearly and specifically expressed as required by Section 316, subsection 2. So none of the parties, the applicant himself and his legal representative, none of them can feign ignorance of the provisions of Section 316(2). They know what is required, and they know that they must set out those grounds of appeal. Because what I see now in the application, in the filing notice, the only thing they did is they attempted to set out those alleged grounds of appeal in the affidavit. And the affidavit is not the application itself, but they attempted to do that in the affidavit. There are 4 grounds which they attempted to set out in the affidavit. And that is not compliance with the law. That is not the application itself. So why have they not complied with the law? They are insisting and begging and pleading with this court to apply the law, to adhere to the law and the rules of the court, but they have not done it themselves. So really, they must be held to those standards. The fact that they've not complied themselves, they must be held to the standards which they want this court to uphold. And the court, in fact, should uphold those standards and strike this matter from the roll, because they have not complied with the provision of Section 316, subsection 2 of the Criminal Procedure Act. This is inexcusable, my lady, and a blatant disregard for the rules of the court, which should not be tolerated at all, because it's clear they are fully aware of the rules. They've read the decisions which apply to the provisions of Section 316, subsection 2, but they choose not to comply with it, knowing what those rules are. On that basis alone, it is submitted, my lady, that this matter should in actual fact be struck from the roll for failure to comply with the provision of Section 316, subsection 2 of the Criminal Procedure Act. The second point in limine, which has been raised by the state, is on the basis that this appeal, application for leave to appeal, which has been raised, is an interlocutory appeal. And in law, these interlocutory appeals are not allowed. They are not appealable at all. And this was also one of the rulings in the matter which was cited by the applicants in the matter of Shangala versus the Prosecutor General, where the court also made reference to the matter of State versus Trovitsky, where it was said that when regard is held to the plain words of the section, an accused convicted of any offense, that is the only construction which can properly be given. In other words, Section 316 does not permit any interlocutory appeal prior to conviction. And that is correct, my lady, because the section that they have relied on, Section 316.1, is also very clear. Section 316.1 provides that an accused convicted of an offense before the High Court of Namibia may, within a period of 14 days of the passing of any sentence as a result of such conviction or within such extended period may, on application, on good cause be allowed, apply to the judge who presided at the trial, or if that judge is not available, to any other judge of that court for leave to appeal against his or her conviction or against any sentence or order following thereon. So it is clear that these applications for leave to appeal should be in respect of convictions or sentence. I have not heard counsel saying that his client has been convicted. Maybe, I do not know what their view is, but I have not heard them saying that he has been convicted of any offense. So on what basis then does he appeal this decision, this interlocutory decision? There's no exception which has been raised by the accused persons as to why they could appeal this order. The applicant has correctly relied on the matter of Zweni versus Minister of Law and Order, which is a South African judgment. The full citation is provided in paragraph 4 of the status of argument. In short, the court in this particular case had said that a judgment or order is a decision which, as a general principle, has three attributes. First, the decision must be final in fact and not susceptible to alteration by the court of first instance. Second, it must be definitive of the rights of the parties. And third, it must have the effect of disposing of at least a substantial portion of the relief claimed in the main proceedings. He then went on his heads of arguments to cite the matter of Shangala versus the Prosecutor General, which clearly is read, where the court held at paragraph 19 that it is clear that there is a general rule against piecemeal appeals in criminal trials, specifically against rulings made in respect of interlocutory orders. This is, however, not a rule set in stone, and it has been held that in exceptional circumstances, interlocutory orders may be appealed against. Inexplicably, my lady, in paragraph 21, the applicant has concluded in his paragraph 21 that the order refusing for the adjournment is in actual fact a final order. That is the stipulation of the applicant. My lady, it is respectfully submitted by the state that the order by the court was not a final order. The court had ordered for this matter to proceed on the 9th of March. I don't know on what basis he says that that order is final, because on the 9th of March, this matter did not proceed. If the order was final, as stipulated by the applicant, then come what may, 9 March, the matter would have proceeded. But the matter did not proceed. What happened to the matter on the 9th of March? There were applications which were moved and the matter was postponed again. And that shows that that order was not final. That's why the trial did not proceed on that particular day. So it does not have that final effect. It has been a month now down the line since the matter was supposed to proceed with trial, but the matter has not proceeded. So we would like to hear on what basis counsel says that this order, which was given by the court, is final in nature. It was not final, and it was in fact changed by the court on the 9th of March when the matter was postponed. Moreover, the rights of the parties have not been definitely determined in this particular matter, because that will be done once a decision is made by the court, either to acquit or convict the accused person, wherever the case might be. Or if issues of jurisdiction are dealt with and it's ruled in their favor, they are released, that's final. Then yes, that becomes something that is appealable. But a mere postponement itself is not appealable, my lady. There are records, in fact, in the magistrate's court where the court may order final postponement for investigations. And when the matter appears final for investigation on that particular day, if a party, the prosecutor, can justify why a further postponement is needed, despite it being final, this court is still empowered to grant another postponement, which is, I see from the records in the lower court, they normally call them final postponements. That shows that the nature of the orders which are given in terms of Section 168 are not final orders. And in fact, if counsel for the applicant had not been ready on the 9th of March, there's nothing that prevented him from approaching this court and substantiating with an application as to why he was not ready on that particular day. And this court was still entitled to hear him on that particular day, on the 9th of March, on whether or not to postpone the case to a further date. That could still have been done. But instead of choosing that route of requesting for a further postponement, if he was not ready, he chose to appeal the decision, which he knows himself that is not final. My lady, the state respectfully submits that if the court was to allow this matter to be appealed, it would in instance mean that every application brought in terms of Section 168 for a postponement is appealable. Even the decision that the court will give at the end of the day today, postponing, if it postpones the matter for judgment to any other date, it would mean that the door is open for them to even appeal that decision of postponement. That is the impact of the amendments by counsel for the applicant. So at the end of the day, my lady, we know that in this particular case, there have been hundreds of postponements, I suppose. I did not count the postponements since the first appearance. It would mean that each and every postponement until today is in nature of fact appealable. So should the applicant so wish, this will open the door for them to appeal every postponement that comes before this court. And this is why Section 316 is in place, to prevent piecemeal appeals to the Supreme Court. That is the whole purpose of Section 316, my lady. It is respectfully submitted that this is an interlocutory matter, and on that basis, my lady, it is not appealable, and the state requests for the matter to be struck from the roll as there are no exceptional circumstances for the accused to be granted leave to appeal this application, my lady. I think that is all for the state submissions on those two grounds.
Thank you, Ms. Gebhardt.
My lady, the state, as we understand it, has raised 2 grounds or 2 points in limine. And those 2 points are, the first one, as we understand it, is that there is non-compliance with Section 316(2) of the Criminal Procedure Act on the part of the applicants. And the second point is that Section 316 does not extend to interlocutory rulings prior to conviction. My lady, we should start the debate by having regard to the provisions that are being cited. That would be section 316, subsection 2 of the Criminal Procedure Act. And that section reads as follows, my lady. Every application for leave to appeal shall set forth clearly and specifically the grounds upon which the accused desires to appeal, provided that if the accused applies verbally for such leave immediately after the passing of the sentence, he shall state such grounds and they shall be taken down in writing and form part of the record. If one has a cursory look at that entire section, and my learned friend hasn't dealt with that issue, is that it also envisaged filing of an affidavit. May not be necessarily in these circumstances, but you'll find it in subsection 3, meaning 3.116, that it contemplates that in certain circumstances, evidence would be accepted by affidavit. But what are we dealing with here, my lady? The point of the defect in the application that is filed is relevant to one question, and that is whether or not this court will be able to apply the test for leave to application. That test is, will another court find differently to what your ladyship has found on the issue of postponement? Are the prospects of success? So the question the court must ask is, if you have regard to the application in its current form, is the court able to undertake the exercise of determining on the test? What your ladyship should shy away from and decline the invitation by the state is to determine whether those grounds are proper, because those grounds or that exercise of whether there are merits in the grounds is a question for the appeal court, not your ladyship. What your ladyship needs to confine yourself to is, are you able to apply the test on the notice and the application as it stands? That should really be the end of the matter.
Is there a proper application before court?
That's the next question, my lady. My lady, you will remember that we warned Mr. my learned friend. I can't say his surname. I don't want to butcher it. We warned my learned friend, the legal representative for accused 8, and we said, your application seems to be missing at page 2. There's something missing. There's a little thing that says you are going to file an appeal, but there's a lot of things missing in your application. Can you please provide us with a complete one? He then answers on those dates that I have informed the court and undertook to provide us with a complete one. Your ladyship, when my learned friend stood up to reply, he ignored that issue completely. We submit that he did so because he has no answer and should concede that the application is not an application that this court can look at or regard as a leave to appeal application, properly viewed. So that's our submission on that first point. We must emphasize, my lady, before I move on to the last point, is that the court, when looking at leave to appeal applications, is performing what we call a gatekeeping function. You look at whether there are grounds. Is the application proper? Would another court, looking at what has been put before it, possibly find differently? That's a purely gatekeeping function. The affidavit does not cure that defect that is in the notice, and that defect is fatal to accused 8. That affidavit that he filed, it does not cure the defect. There are actually no grounds in the notice, if you view them strictly speaking. What is the function of a notice in our proceedings? It defines the jurisdictional foundation of an application. Yes, we support it with an affidavit to supplement those grounds and to point out what we rely on as applicants or litigants. But if the notice itself is defective, it cannot be cured by the subsequent filing of an affidavit, whether correctly or so. To hold otherwise, my lady, would be to read something into section 316(2) that our legislature did not intend. I'm not going to repeat the cases that my learned friend has referred to. However, on that point alone, this application fails. It should be struck from the roll. The second point, my lady, that is raised by my learned friend for the states, is that the ruling is an interlocutory ruling and not susceptible to an application for leave to appeal. My lady, you will note that in our heads, we address this issue but before we address our heads, my lady, we have no intention to oppose. So my learned friend was well aware that we are going to say the order you seek to appeal is not appealable. But he says nothing in his heads of argument. He does not simply address that point at all. If he does, if I'm mistaken, let me just make sure if that's the point he did not address. It's the moot point he didn't address. I apologize, my lady. The issue of the appealability, my lady, he made a very secular argument around it, which I will touch on briefly. My lady, we have alerted the court, all of us are alive to the rule against piecemeal appeals and what it's there for, especially in criminal trials. We've relied on the authority of S versus Malumo, my lady, wherein the Supreme Court confirmed that interlocutory rulings in criminal proceedings require exceptional circumstances before they may be appealed, applying the policy considerations that underpin both 316 and 316(2). We also rely on the authority of Shangala versus the Prosecutor General, that 2025 matter, wherein this court confirmed that there is in fact a general rule and held that only exceptional circumstances may justify departure therefrom. My lady, the applicant's main complaint is that he should have received more time. But does that constitute an exceptional circumstance to depart from the general rule? Does it warrant departure from the rule against piecemeal appeals? And even if, for argument's sake, the exceptional circumstances existed, the ruling must still satisfy the three-part test as it is set out in Zweni versus Minister of Law and Order, which was repeated in D. Savino versus Namibia, Nedbank Namibia. And what are those requirements? The first one is that the order must be final in effect, my lady, meaning it must not be susceptible to alteration by the court of first instance. The second requirement is that the order must be definitive of the rights of the parties. The third requirement in Zweni is that the disposing of at least a substantial portion of the relief claimed in the main proceedings must be what the order says. So on all three of those requirements, your ruling of 21 January fails. It simply is not an order of final effect because you exercised a discretion under Section 168 of the Criminal Procedure Act, as correctly pointed out by my learned friend from the state, as to the date of adjournment for the case. You retain, my lady, as a court, as a trial court, full powers to address any genuine unfairness arising from inadequate preparation as it manifests in the trial of any of the parties. It could be me, it could be accused 8, it could be accused 2, it could be accused 3, as it arises during the trial. You retain that power to address any genuine unfairness once established. Your ruling of 21 January 2026 does not and is not definitive of the rights. The applicant's Article 12(1)(e) rights were not permanently extinguished by your ruling, my lady. They remain fully enforceable before the trial court throughout the proceedings until the end. The ruling of 21 January 2026 also does not, it doesn't dispose of a substantial part of the main relief. My learned friend in his head says the main proceedings are the criminal trial on the merits. My lady, an interlocutory postponement ruling disposes of nothing in the main trial. Absolutely nothing. We haven't even touched what are the issues in this trial. So nothing is disposed of by that ruling. So my learned friend cannot argue that the ruling is final because it disposed of the adjournment application. Every ruling disposes of an application before it. The question is whether it is definitively and it determines a substantive right in the Zweni sense. If the applicant's logic were to be accepted, my lady, every interlocutory ruling in every criminal trial would be appealable, either by the state or by any of the accused person, which would entirely defeat the general rule that we've been emphasizing against piecemeal appeals. My lady, I pause to note one further matter relevant to appealability, and that is the findings in your postponement ruling regarding the history of delay in this matter were confirmed and elaborated upon in your judgment of 23 March 2026, and that is at paragraph 60, paragraph 69, and paragraph 70 of that judgment. You noted, my lady, or this court noted, that the deliberate delay finding is a finding of fact, that the concept of time has lost all meaning in this matter, and that the state has not led a single witness after 4 years and 5 months on the roll. These findings reinforce, my lady, both the absence of a misdirection in the postponement ruling and the absence of any exceptional circumstances that would justify a departure from the general rule against piecemeal appeals. So it's on that basis, my lady, that we submit that that point should succeed. This is not a ruling that passes or jumps over the line for appealability in the Zweni sense. As it pleases the court.
Thank you, Mr. Nghipunya.
As it may please the court, my lady.
Yes, you can first address me on the state's first point in limine, namely that the notice of appeal or notice for leave to appeal is fatally defective, and thereafter you can address me on the fact that this is an interlocutory ruling that is not appealable.
I was prepared, my lady, to first dispose of the second notice of point in limine, since that one I can dispose of a bit faster. I don't have a lot to say on that particular point in limine.
So you first want to address the appealability?
Yes, my lady. May I do so, my lady?
Just a moment. May I proceed?
As it may please the court, my lady. I know it's okay. My lady, the common authorities on this aspect have already been cited. I don't want to repeat them, but just to say the Zweni matter and the Shangala matter and the Malumo matter. All of this, they speak to the appealability of interlocutory applications rulings. Our understanding as the accused number 8, my lady, is that we understand the law to mean this, that the general rule is that if it's an interlocutory, you can't appeal. But if there are exceptional circumstances, if you can show to the court that there are exceptional circumstances, then you are exempted from complying with the requirements or the guidelines that are laid out in the Zweni matter. What you need to show to the court is that it's an exceptional case or exceptional circumstances. Then the court may give you leave to appeal. Our submission, my lady, is that if we take into account the right at stake here, and which right is that? That is the right to adequate time to prepare for trial, which is an important integral part of the right to a fair trial. Because if you were not afforded reasonably sufficient time to prepare for trial, you will not be in a position to effectively defend yourself before court. That right is so important. That is why that right is entrenched in terms of Article 131 of the Constitution. And because of that entrenchment, that is what we submit establishes exceptional circumstances in the case, because the accused would now be forced or pushed into a trial in which he was not given adequate time or reasonable adequate time to prepare for trial. If indeed he participates in that trial, since he has no option, and he does not properly defend himself, he may be convicted when he shouldn't have been convicted had he had reasonable time to prepare for trial. And for a country like Namibia, my lady, if regard is had to the history of this country, as far as that right to a fair trial and adequate time to prepare is concerned, that right is very exceptional. And that is what we submit, that because of that right, applicant number 8 needs not comply or meet the guidelines that are laid out in the Zweni matter. Because number 1 is, of course, an interlocutory ruling. Number 2, the right at stake is so important. And it may be argued, my lady, that, well, he can appeal if he goes into a trial unprepared and is not satisfied with the outcome. But why wait for the injury to be done when you can prevent it now? Again, my lady, I would still want to go back to that point 22.2 of accused number one's heads of argument. And I want to read it, what they say here, as far as that issue is concerned. That the applicant's right to a fair trial under Article 12 of the Namibian Constitution, including his right to adequate time and facilities to prepare his defense under Article 12(1)(e), was not permanently determined or extinguished by this ruling. We submit that is not true. It's a misrepresentation. The court decided on that particular day that the trial should start on the 9th of March. The reason why it did not start is because there was another application. And the reason, and also we refer the court to the court's own ruling when it cited that because accused number one's defense lawyer is ready to proceed with the trial, therefore, it's as if it's expected that accused number 8's legal representative should also be ready. The court is not looking at the fact.
Can you refer me to the paragraph on my ruling where that is implied?
Can I come back to that, my lady?
You may.
Yes. Further to add to that, my lady, to support the argument that the right is what makes it exceptional, we must further look at subsequent attempt by the Honorable Court. We had an occasion where, and I think that was the first time when since I came on board for accused number 8, that after remanding the matter for trial, there was a head of security that was engaged by the court, before court. And that was done, I think, barely 2 weeks before the 9th of March. We are submitting that is because the court realized the importance of this right. However, or unfortunately, it was for the first time, as far as I'm aware, that the court heard from Commissioner Nunwa that indeed there are only 2 consultation rooms at the Windhoek Correctional Facilities. That simply means that when the postponement was made, the court was not properly informed of this. It was not aware that there are only 2 consultation rooms. And they further said they are not exclusively reserved to accused number 8. If the circumstances is such that things that are beyond his control are making it impossible for him to have sufficient time to prepare, then our submission is that, my lady, it then becomes exceptional that he be allowed to appeal that decision that was made to remand the trial date when he was not afforded reasonable, sufficient time to prepare for trial. Then I proceed on to read that paragraph, that these rights, that is now paragraph 22.2, these rights remain fully enforceable before the trial court throughout the proceedings. If applicant's legal practitioner genuinely cannot represent the applicant competently due to insufficient preparation time, the trial court can still address that. The way we understand this point, it's as if they are saying, we were not genuine when we made the application for an adjournment to be afforded 5 to 6 months to prepare. But they are not explaining where they are getting that. But at least they are admitting that we are entitled to adequate time and facility to prepare for trial. Again, on this point in limine, my lady, what appears to be the main objection by accused number 1 and 11 is their claim that their right to a trial within a reasonable time will be infringed. But if we then look at what they are saying in point 22, paragraph 22.2, they are then contradicting themselves, because they are saying if the matter is postponed, we want to start the trial, you violate our rights to a trial within a reasonable time. But then they come again and say, but you can always ask for remand if you really need time to prepare for trial, so that you can be afforded that time to prepare. As it may please the court, my lady, I now move on to the first point in limine, which is that according to the respondents, that there is no valid notice of appeal before court. My lady, we have to start from this angle. The respondents, and I would say the respondent because their argument is actually the same on this aspect. They read section 316. Then they used it to say, because in the section, the words used is conviction and sentence. You cannot appeal. But if we are to also then read the section 316, we can then say it does not make provisions, it does not cover for appeals on interlocutory matters. If we are to accept that it talks only about conviction and sentence.
Then in terms of what are you appealing this interlocutory ruling, if not in terms of section 316?
No, I'm trying to go by their argument to say if that is what they are saying. If that is what if they are saying, it's not appealable because the section talks about conviction and sentence. We would also then argue and say, because it also doesn't talk about interlocutory ruling, that the requirements that are required for filing the notice of appeal on conviction and sentence should not be strictly applied to appeals on interlocutory rulings. We also would like to refer the court to that section 1 of the Criminal Procedure Act does not actually define an application. That's why you find it in, doesn't define the word application as it appears in section 316 of the Criminal Procedure Act. And in terms of that, application is an application on a notice of motion, which should ideally be supported by an affidavit.
Is your argument supported by case law?
Our argument, my lady, is supported by the fact that in the definition of the Criminal Procedure Act that we are relying to, the word application is not defined. But you would find that definition somewhere else. And where you find it, it says notice of motion, which ideally should be supported by an affidavit. To move on, my lady, what I understand the state to be saying is that they are not so much worried about the substance, but the form, in the sense that, according to them, there should not have been an affidavit. But what are they saying about the grounds themselves in the affidavit, as laid out in the affidavit? We are submitting, my lady, that the grounds of appeal, if we are to look at the introduction in that affidavit, that it links up to the notice of appeal, and it sets out the grounds of the applicant number 8, and further explains them. Just a moment, my lady. If we are to accept that interlocutory appeals can be done in exceptional circumstances, and that they are also not expressly defined there in or included in section 316, then we submit that we should also accept that exceptional process, as in filing that notice, can also be allowed. Because the issue seems to be, it's because it's an affidavit. We admit, yes, it's an affidavit, but it's an affidavit that has grounds that are properly explained and substantiated, and that the court, if the court reads those grounds, the court would be able to understand what applicant number 8 is complaining or appealing against, or intends to appeal against. Court pleases, my lady. That's our submission on this point.
Thank you. Mr. Luzabezi, in reply?
As it pleases the court, my lady, I'm just on points of law. The applicant was asked by the court in terms of what law is he appealing this decision. My lady, it's clear. It can only be section 316. I'd just like to refer the court to his affidavit, which was filed before this honorable court at page 3, paragraph 4, where he had stated that the purpose of this application is to seek leave to appeal the judgment and or ruling and order of this honorable court in S versus Gustavo and others. And then he goes on to say, okay, then he mentions the date. He stipulates that granting accused as legal representative a period of 1.5 months to prepare for trial. and to remand the matter for trial without resolving the issues of legal aid tariffs that the court itself found could affect the fairness of the trial on 19 January 2026. And the important part, he stipulates today that in terms of Section 316, subsection 1 of the Criminal Procedure Act, and sets forth the orders of court this application for leave to appeal relates to, as well as the basis for such application, has required under Section 316(2). They are not ignorant to the provisions of these sections. They know that these are the provisions that they were using to apply for leave to appeal. It specifically said there, 316(1) and 316(2). So they were well aware that these are the provisions that they must comply with. There's no other provision. And on the amendments that are being made that it's a proper application because it's on affidavit, that is not correct. There is no affidavit in law which is required for this application in terms of Section 316(1) and 316(2). You merely move your application. The affidavit is only required when one wants to lead further evidence as provided for in terms of Section 316(3). Because that section reads that when any application under subsection 1 for leave to appeal, it is shown by affidavit that further evidence will be presumably be accepted, and it goes on. So there needs to be an application supported by an affidavit in terms of Section 316(3). Apart from that, my lady, to show the fallacy of the argument that you need an application, or the application can be moved by way of affidavit, under Section 316(2), it makes provision that every application for leave to appeal shall set forth clearly and specifically the grounds upon which the accused desires to appeal, provided that if an accused applies verbally for such leave immediately after passing of sentence, he shall state the grounds and they shall be taken down in writing and form part of the record. So the second provision of that, it empowers an accused person to apply verbally to the court for leave to appeal. The only thing they need to do is just to stipulate that, well, I intend to appeal this decision. These are the grounds upon which I'm appealing this decision. That's it. Then they do not need to do it under oath. It's just a verbal application. It does not need to be under oath. So if such application does not need to be under oath, why should they provide an affidavit for the other applications which is written? There's no such requirement. And that is not the correct standing of the law, my lady. That is all for the state submissions and reply.
Ms. Gebhardt?
My lady, my further submission is also, or a reply is on a point of law, just to invite the court to have regard to that decision that we've referred to in our address to answer the questions that are being posed by my learned friend about the appealability of the order. You would find those in that Malumo matter, my lady. I just want to give the court the correct citation. It's S versus Malumo, in brackets 2, 2010, Namibian Supreme Court, 10 SC. That judgment, my lady, does a complete exposition of what Section 316(1), 2, as well as 316A pertaining to states' appeals are treated as in our jurisdiction, my lady, as it pleases the court.
Thank you. Yes, Mr. Shanghala. I assume you are speaking on behalf of accused 2 as well?
Are you inviting me to participate in this application?
No, please don't. No, we're finished with the hearing of the application for leave to appeal the postponement ruling. I have received, I'm now at your application for leave to appeal the recusal ruling. So I have received that, and I would like, unless there's anything else you want to say, before I give dates for heads of argument, I can give the dates.
Well, I just need to inform you that the High Court, Justice Mwatelulo, Deputy Judge President Mwatelulo, is seized with a status hearing in the Part A of the review that seeks to stay these proceedings, a status hearing for the 30th, which we file our reply on the 27th. So if you can take into account those dias, and then I will take whatever dias here and then ask Justice Mwatelulo to take them into account if that period of time will be impacted.
Yes, what I then will do, if there is any opposition to the application for leave to appeal the recusal hearing, such notices of opposition should be filed on or before the 16th of April. The applicant sets of arguments then on or before the 23rd of April. If there is any opposition to the application for leave to appeal, those sets of arguments to be filed by the 30th of April, and the hearing we will then do on the 5th of May. I will then also reserve the ruling on the application for leave to appeal. The postponement ruling will then likewise be given on the 5th of May, just for convenience sake, so that we will only have one court appearance.
As it pleases the court. My lady, we have submissions. I have instructions to make submissions on the further conduct of the main matter. We accept that the ruling on the application for leave to appeal the postponement is now postponed to the date you've provided. We also accept that your ladyship has set out a timetable in respect of the leave to appeal for the recusal dismissal. We wish to make submissions on the further conduct of the main matter.
Okay, just a moment. Mm-hmm.
As it pleases the court, my lady. My lady, as I've indicated, the first accused person accepts that the application for leave to appeal against the postponement ruling, that matter is postponed for judgment. There's no issue with that. They also accept that the timetable has now been set for exchange of papers in respect of the leave to appeal the dismissal of the recusal application. There's also no issue with that. What the first and 11 applicant wish to make submissions on is the automatic stay without an order to that effect of the criminal trial because of this application, of these two applications. So the submissions I'm making now, my lady, are in light of those two pending applications.
May I suggest, because it is of relevance to all parties, that I request in all the heads of argument that that specific aspect be addressed.
My lady, that would be correct if we were in fact opposing that application, which determination we have not made. The submissions we are making now is to address the issue of whether there is an automatic stay of these proceedings due to the leave to appeals that are pending. And we beg the court to hear us on that matter before the order is made today or tomorrow or whenever, because we are here for the benefit of the court and all the parties in the proceedings.
My apologies, Judge.
May I proceed?
Sit down,
Yes, I just want to give
because I was not done.
No,
Yes,
I understand. I will give you an opportunity, Ms.
This
Gebhardt.
is the court, my lady.
May I just make a remark on this issue of sitting and standing? It's the second time now. It's just courteous that when somebody else stands up, we don't just stand up because we are incapable of sitting down. It's because we'd like to address the court and be given some redress on the issues we stand up for. Please, Judge, in the future, if this would reoccur again, I'm going to ask you to please tell Ms. Gebhardt that we do not stand or sit here for the like of it. We are taking issue with issues being raised. Now, the point I'd like to make...
We also don't interrupt submissions. We allow other parties to finish and then we make. But if evidence is being laid, that's something else. When I'm making submissions, I should not be interrupted. That is the reason why I was asking if I should sit, and then the court directed me to sit, because I was making submissions. Ordinarily, one does not object to submissions.
Touche. That's why I sat. Touche. That's the word.
Are you
Yes, I'm saying...
are you both finished?
No,
I'm finished
Thank
for
you.
now.
no,
Yes,
I'm not...
If the court has a problem with the manner in which the parties conduct themselves in court, believe me, I will inform you of such.
Thank you, Judge.
So
point I wanted
we
to-
still have a long road to go. Please, let's keep it civil.
Thank you, Judge.
And-
The point I wanted to make was, when you made the intervention when Ms. Gebhardt was seeking your permission to make submissions with regard to the question that she posed and wants to answer, I thought you were minded by the fact that it would only be fair and in keeping with a fair trial right for other parties that intend to make submissions in response to the submissions of Ms. Gebhardt on that issue, which is an important issue, not only for this particular recusal matter that's before court, but possibly for the purposes of the court making law that may be utilized not only in this case going forward, but in other courts. So the submission I'd like to make is, if the court can have that question framed and then specifically address, it happens all the times in the court, where the court seeks specific issues to be addressed to it. The reason I say so, Judge, is because we now know the preceding discussion has shown to you sufficiently, and you are a magistrate of long standing, that there is a lacuna. I've said this before, and I've just been admonished by the prosecution. Yes? Yeah, I'm going to say what I'm going to say, which you've been admonishing me for, is that instead of just opposing me for the sake of opposing me, they should join me in requesting the judge to make an order to the rule maker to address the gaps in the rules. In the absence of that, the court is well suited to make and fill those gaps, at least for the purposes of this trial. So the suggestion is, for the avoidance of doubt, is that the question be framed by the court. We are permitted, if we so seek, not to do with anything per se with the leave to appeal the recusal, but if anybody would like to participate, and then the court takes the time and makes a substantive ruling in that regard that will apply henceforth in these proceedings, because a matter of recusal can arise tomorrow again from the conduct of the court. That is the submission I wanted to make. And hence it illustrates why I stood in as an exceptional circumstance to make the submission, if it pleases the court.
Thank you. I just want to quickly note down what you said. Ms. Gebhardt?
It seems my colleague also wants to stand up next to me, my lady. My colleague wants to say something.
My lady, if the court recognized Ms. Gebhardt first, she can just go first if she also wanted to say something.
Ms. Gebhardt, yes, I just want to inquire from you, are you about to address the court on law, on case law, advancing arguments
My lady?
on the matter that you raised?
My lady, I differentiated when I started, and that is why the opposition is coming fiery and fiery. The two interlocutories, my ladies, have been postponed. This court is entitled to hear any of us before the court makes an order as to the main matter. The court can later disagree with me, but I'm entitled to place on record what the submissions are in respect of the main matter. We've done the ones on the interlocutory, both of them. We have no issue with the timetable. The other matter is postponed for ruling. We should not be precluded to be heard simply on the basis of on the issue of what must happen to the main matter. The court can always overrule us, but we must be heard before an order is made.
I am just concerned that the submissions that you are about to make might be premature.
Then my lady can direct as follows, as such, when I've done the submissions. I am entitled to make
The problem just
submissions.
is, as soon as I give you a chance to address me, I have to give everybody else an opportunity to also address me.
That is the nature of this proceedings, my lady.
And there's nothing before me.
My lady, when the order is being made to postpone, each party must be heard. Whichever party decides that they are ready to address you today cannot be stopped, my lady. If the other party is not ready, they can say, no, we've heard the submissions of accused one, but we wish to take 2-3 days and consider what accused one has said. Because when we come to these proceedings, we anticipate 3 orders today. One pertaining to what must happen to the leave to appeal in respect of the postponement application. The second order as to what must happen to the leave to appeal in respect of the recusal dismissal, and then what must happen to the main matter, because, my lady, let's not forget, the main matter is set down for this week, it's set down for next week. We don't have orders vacating those dates. So before the adjournment is made in terms of Section 168, we are entitled to be heard whoever is not ready to make submissions on when you adjourned, but that order cannot be made without accused 1 and accused 11 being heard if they are before you.
I understand what you are saying, but what am I listening to? An application for
It's
what?
not an application, my lady. It's
Then
an
no-
objection to postponing the matter automatically.
To the 5th of May.
Yes, my lady.
So you are... What are you then asking for? For the matter to start with trial tomorrow?
Yes, my lady. We are going to object to the postponement of the trial proceedings. And all the parties are entitled to be heard. What is not correct is for one party to be stopped to make submissions before an order is made.
But still, then I am still of the opinion that, because this is out of the blue, that you are in effect then bringing an application from the bar.
It's not an application, my lady. It's an objection, I state again. It's an objection to automatically...
But an objection to what? An objection to the court's ruling, because
Let
I
me-
directed, the court directed
Yes.
the date. So against what? Against which of the parties are you objecting?
Thank you, my lady. Let me clarify so that the court is on the same page with me. The one matter is postponed for judgment. We have no objection to the postponement of that interlocutory application for judgment. We were heard, the court decided to postpone. We have no objection because we are done with that matter. The second matter, the timetable has been set, my lady, for whoever intends to oppose it. And then it will be heard on the 5th. Now, what has been happening is that the main criminal trial has been postponed automatically, and we are anticipating that the court intends to do the same. So we wish to be heard before the main criminal trial dates of tomorrow, next week, are vacated, my lady.
No, the objection is overruled. If, for in argument's sake, I grant leave to appeal the postponement ruling, what will happen to the trial proceedings?
Those are the issues, my lady. I haven't made the objection. What is happening is I'm being stopped from making the objection. So my ladyship, your ladyship wants to overrule an objection I have not made yet. That is the point I'm making.
I still do not understand the procedure that you are following and what you are trying to achieve. There's no application before court. I have, in effect, if we want to be sticklers for rules, I am now functus officio.
My lady,
I have remanded the case until the 5th of May.
all right, that is where we misunderstand each other. My lady, we understood you postponed the 2 interlocutory applications. Have you postponed already the trial matter and vacated tomorrow's dates?
It is not necessary. This is not a civil matter.
If that's the court's position, we will then explore my client's rights in that regard.
Please.
I appreciate the clarity.
Please, because I would, as I said, maybe if one of the parties is opposing the application for leave to appeal the recusal ruling, the applicants then also maybe keep in mind to address me on the matter as raised by the court and, if I understand correctly, also by Ms. Gebhardt, as to the status of the case pending the finalization of the recusal.
Yes,
But for now, the matter is remanded until the 5th of May for ruling.
My lady, there's just one challenge with that ruling. What if the parties, or what if, for example, accused 1 does not oppose that recusal application because he wants to focus on other things that are more important to him? What about his submissions? So, my lady, what I invite and request the court to do is that even if there are parties who don't oppose that application, the issue of whether those pending interlocutory applications can be addressed without having to oppose the recusal. Because it remains a live issue, even with the parties that don't intend to oppose. Because then we would still be heard, because that is what we are entitled to. We need not oppose the recusal to be heard on the issue of what must happen on the further conduct of the criminal trial, for which dates have already been set. So that is my request to the court, that the order should reflect that even if there are parties who don't intend to oppose the leave to appeal the recusal, because we want to get out of this and focus on the issue. If there are parties who don't intend to oppose the leave to appeal the recusal application, they should also and are invited to address the court on the issue of whether these two pending applications stay the commencement of the criminal trial. That is my request in the
court
alternative.
will grant your request. I will
As it
also,
pleases the court.
to be fair to all the parties, I have to go and read up on that specific matter,
That is
whether
all
I
I
am
ask.
even entitled to do so.
As it pleases the court.
So it might be that we will have to revisit this point, but for now the court will grant your request. Sorry,
I accept that, my lady.
Mr. Nimwata.
Yes, my lady, of course, I now understand that the accused number 2 and 3 applied for leave to appeal their recusal. Of course, I have not yet received their papers. And I don't know what would be the position of my client once I consult him. He may well decide that he wants to participate from whichever side, I don't know. I also take note of the fact that what I want to ask, should that happen and my client wishes to participate, is it okay, like I think what happened with Mr. Alexander, that they didn't file heads of argument, but they came to submit from the bar. Can we forego that part of filing heads of arguments? And just
When
come
was this with the
recusal application itself? They did not file heads of argument,
No, they
did they?
They were not party to the original application, and then they filed what they termed a supporting affidavit.
Okay. So,
And then they filed heads of
okay,
argument.
my apologies then. Which means we just have to file heads of argument if we want to participate.
Yes, you file a notice of opposition with
God,
yes,
this is my
Mr. Engelbrecht.
I'm mindful of the fact that the court makes certain orders, and then I assume that because of the order that the matter has been postponed by the court until the 5th of May, then automatically the dates 13 to 24 April then become vacated.
Yes.
I would just want to place on record as far as accused 9 and 26 is concerned, that we are ready all along as far as the main trial is concerned. I must also then place on record that the court order that I follow, that indeed dates have already been agreed between the parties for the rest since January up to December. Seeing the light that there's no applications and that I don't know when we would start with the main trial, whether or not I must still reserve the dates or can I clear my diary for that purpose in order for new work, because I'm now reserved, no payments is forthcoming from legal aid, and that is the only thing that I have. Must or can I then vacate, clear my diary in order for new work to be accommodated, because I cannot engage any other work because of the dates that has already been reserved. And every time I come to court, like from today up to 24th, I could not take in new work because of the dates that has already been reserved. And that had a financial application on my firm. That is only a business that I want to make. As the court pleases.
May it please you, my lady. My lady, we've been obviously sitting idle in this train of justice that is quite slow moving. However, every accused person has a constitutional right to a speedy trial. And our courts have held that we need to assert the accused person's right in respect of that right. Now, we do not have an objection to the court's order. The court's order stands. We can't actually object to a court order. What we need directions from this honorable court, my lady, is in respect of us, those that want this trial to proceed and that are ready to proceed with this trial, we want to assert our rights to a speedy trial. Now, in as much as the other accused persons have their rights, they have their right to adequate time and facilities. They have their right to challenge the impartiality of the presiding judge. We have our Article 12(1)(b) right to a speedy trial. And we intended to make submissions to this honorable court in respect of asserting that particular right. It's not an objection, therefore we need directions from this honorable court. If we have to file a notice to oppose in respect of a recusal application, we are limited, my lady, in respect of answering to those points in law that the court should determine whether there are reasonable prospect of success that a different court may come to a different conclusion. The aspect of prejudice does not come into play there. So we won't be able to respond to a recusal application and assert our rights in heads of arguments. The only thing that we can do is when we assert our rights, we need not bring a formal application, my lady. This is something that we will normally move from the bar. I believe that even if we were in the magistrate's court or wherever we are, we would say, but we object to this. We are not objecting to the proceedings here. We are saying, let the proceedings run. What we want to do, my lady, is we want to assert our rights. We have been scheduled. The lady must understand.
But what is your remedy?
My lady, what we propose
That is my question to Ms. Gebhardt as well. What is your remedy?
If the court seeks an application, my lady, we can either do that. We can.
But an application for what?
An application for this matter to start, my lady, because we will be kept in limbo, my lady. I'm looking at these applications. We should not look at everything in vacuum. The law can be quite practical. We have an application for leave to appeal. I'm going to start with that one. That application for leave to appeal, it's only the preliminary points that have been argued today. The court can then decide the application is good and I'm going to hear the application, or the court can say no. Then the 8th accused then have the right to petition. Then they would say, oh, we've got a petition pending. Let's wait for the petition to be finalized. The same can be said in respect of the recusal application. Either they are successful, they are granted leave. Are the court's hands going to be tied? Are the accused person's rights going to be violated throughout this court process? When will they assert their rights? Because they can then also go and say, but we are going to file for a petition, or we're going to be granted. And we know how long the Supreme Court takes in these particular matters. We cannot wait. Justice Parker once remarked that the train of justice waits for no one, and the only persons that are being affected here are the accused person. My client is 68, turning 69. This trial can easily take about 10 years, and we have to assert his rights. So what we propose, my lady, is that even during the course of this week, that we rather come and we make submission to this honorable court, either by way of a short motion, notice of motion or an affidavit that we file to assert their rights. The state can then oppose and all other parties can oppose, and then we argue it on Monday. We cannot wait a month. Every time it's a month, 2-3 months before this matter starts, my lady. The proposal is therefore truncated timelines in respect of filing our applications to assert our rights, and then for those parties to oppose, and then this matter to be heard even before the 5th, my lady, because we cannot wait that long until...
I am always open for suggestions. What I then will do, based on your request, is to consider, let us reconvene on Wednesday. I understand that you want to assert your rights, but the court's hands are also tied by pending applications before it.
And that is what we wish to address.
That is exactly what you wish to address. I understand.
Because it does not automatically stay the main proceedings. Interlocutories do not automatically stay. That's something for the court to determine.
No, I fully understand that. My problem is just with recusal, because that is different. I think we are all aware of
even on the law of
fact.
recusal, my lady, even in the Zuma judgments that my learned friend referred to, there are instances where the trial have gone on, and then the court will decide what are the prejudices.
That is why I asked that I be addressed on that specific issue. I want to give the parties an opportunity to address me on that.
As you please the court, my lady. We will be indebted to the Honorable Court.
Thank you, Mr. Shanghala.
Yes, Judge, I initially rose to object to you asking that when there are parties who want to address the issue raised by Ms. Gebhardt, that they can also include that in the issue that relates to the recusal. That's how I understood you. But I think it's been clarified now in your interaction with Mr. Florian Bierkes and Ms. Gebhardt again, that you will probably make an order in which as I requested you in the beginning, to rather just allow that question to be framed and you are answered. Or, and this is the clarity I seek, it is a question that must be answered whether you participate in the recusal, yes or no.
Yes,
That's
I think
another issue.
give me time until Wednesday. I will try to see a way forward which will be procedurally correct to attempt to do that.
In that quest of the court for us to come back on Wednesday, I want to suggest to the court and remind the court and remind all the other accused persons and their legal representatives that I stood here and made an application for a separation of trial. That's the first thing I said. I wanted to say to you. I made an application for a separation of trial. Lo and behold, I was opposed. Not by everybody, but I was opposed. Should have separated. Secondly, Judge, and this is why this is important, there is a pending matter in the High Court seeking to shorten, if not extinguish, some of the issues before this court. All the parties, save for the state, have bothered or been minded to participate. Now, I understand that the sentiments you made, you are functus officio, that this is the court that must deal with those issues, that all these other applications that I made were a delay strategy. You're functus officio, you made them. If that matter, and it will be heard on a date to be determined on the 30th of April, finds that, Mr. Shanghala, there are merits I have picked into your application into Part B. There's reason for me to stay these proceedings here today. That puts you in a dilemma, Judge, with regard to recusal. Even if you would have determined the issue of the leave to appeal before then, because that date will only be determined on the 30th. I'm just highlighting these issues for you so that it is known that if it seems that there are those who don't want to assert the right to a speedy trial, the right to a speedy trial is but one of the rights that must be taken into account in the calculus of a substantive fair trial. And a trial cannot be fair if it is predicated on unlawfulness to start with. I would like to remind my co-accused and their legal representatives at this point. So, Judge, when you consider us coming back here on Wednesday, please, that is the frame of mind. There is an option for those who feel that the train is going slow. They must get on a faster Deutsche Bahn. This Deutsche Bahn here has to allow me the full amplitude of my rights, as it must allow accused 1 and anybody else who wants to accuse 4 and 9 and whoever, you know? I'm happy if they are happy to go and rush into a trial of irregularities. But what we are doing, if we are saying that substantively, that must be. Lastly, Judge, the irregularity that you so pointed out was that, yes, matters may be made from the bar and said from the bar, but up until now, no application has been made to adjourn. An application must be made, actually. Somebody must stand up and say, I hereby apply that this matter be remanded to when? If, in the circumstances, the court has not already, as you have, and you are functus, determined, rightly as Mr. Engelbrecht has said, that those days are vacated for the very reason that I indicated before. That if it then turns out that your sentiments about lack of merit and delay strategy actually undercut the very point of the legitimacy of a court, because another court can find that indeed there are merits, then we sit with a quagmire. I so submit to that, Judge.
Mr. Nghipunya,
Yes, sorry, Mary. This is my last point. I just wanted to also inform the court that my client, accused number 8, is also a participant in the review application in the High Court. I fully understand the concerns of the other accused that want to start with the trial. But what I also realized is that they are not opposing the review application in the High Court, which means even if, my lady, you dismiss the recusal and the appeal, depending on what may come from the High Court, that could still affect them unless they apply for separation of trial. That's the point that I just wanted to say.
Thank you.
Sorry, Judge, may I be excused from attending Wednesday? Because I need to prepare. I have little time, Judge. I'm in a maximum prison facility. I am defending myself and my co-accused who are defending themselves. And I need to prepare now for submissions that you are going to, which impede on my other preparation for the 27th. And I have received a voluminous response from the Prosecutor General, answer that I must reply to. Because apparently the coming here is to just ventilate issues. I still remain vested with my rights, whatever you ventilate on Wednesday, really, quite frankly.
Well, quite frankly, the court would prefer your presence on Wednesday.
Okay. Thank you, Judge.
Thank you. Yeah, Mr. Nimwat.
About one aspect, I didn't explain. The reason why I mentioned the issue of not opposing is because of the prayers that are being sought in that review application. And one of the prayers is to stay these proceedings.
Yes.
Yes. Maybe for Wednesday, are we able maybe to come after 11? Because I have another matter, my lady, at 10 in the High Court in town.
For what is?
It's on Wednesday. It's a criminal matter, my lady. Criminal matter.
Yes, the case is remanded until the 15th of April. I will make it 10 o'clock. This will be exclusively for the parties that are aggrieved by the pace at which this case is moving to come to court, and to inform me what you intend to do on that matter. I will, on that day, also give further directions as to the question whether recusal automatically stays the proceedings. In the meantime, the ruling for the application for leave to appeal the postponement still remanded until the 5th of May, accused 1 through to 9 in custody, accused 10 bail extended.
As it pleases the court.